Will there be justice for Baeleigh Maurice? The 9-year-old was hit by a truck while walking her scooter across a street in Saskatchewan on her way to school. It was only 9 o'clock in the morning on Thursday, September 9th, 2021. A few months later, the driver, Taylor Ashley Kennedy, was charged with impaired driving causing death. Now, though, those charges have been stayed because the trial took too long. This has left the family of Baeleigh devastated, including her aunt, Rain Mahingan.
This little girl deserves justice, and that's not what we got.
And so today, CBC's Dan Zakreski, who has covered court for more than 3 decades, will help us unpack this. He has seen a lot over the years, but the day these charges were stayed is now etched in his memory.
When the judge, after spending 2 hours of going through all this detailed analysis, suddenly just said the charges stayed, there was just this sort of moment of stunned silence. And then the first thing I heard was, "Oh my God."
And so today on Blue Sky, we will be joined by reporter Dan Zakreski, who will walk us through how this happened. And then later in the show, we'll talk to legal aid lawyers across the province who will tell us how often the court system sees these type of delays in their day-to-day work and how they think the justice system should be improved. If you have thoughts on this, you can email bluesky@cbc.ca. And so here is the CBC's Dan Zakreski telling the story of how we got here.
Like, she was hit by this truck and she was grievously injured, but she was still alive on the street. So, you start looking at some of the different elements here. The police that arrived on the scene knew it was bad right away. That came out in court. And I have my notebook here with me, my trial notebook that I went back through because I'd sort of forgotten some of the horrific details. And it was sort of a minute-by-minute breakdown. First of all, you've got this young girl who's out on the road, is grievously injured. Her family live nearby, so they're coming out onto the street. You can imagine how upset they are. The police said that they called every available unit that they had in the city to the scene because it was getting out of hand. I went back and looked at my notes. You have Taylor Kennedy, the young woman, who is first of all kept just sitting sort of on the curb. And that wasn't working because people in the neighborhood spotted her and they were giving her death threats as that happened. You've got paramedics and police gathered around this dying little girl with her family, and then the crowd gathering in the neighborhood. And then they're trying to do their police work and investigate. It was interesting because I knew what we were going to be talking about here, to go back in my notes and read the officers at trial saying over and over again that nobody thought that there was impairment was going to be an issue here. This was a horrible accident where you had a girl that was dying in front of her family on the street and trying to manage everything that went around with that. It wasn't until, an hour or so after the crash that you get into like the 10:30 in the morning that the sort of capital I issues emerged, because they have Taylor Kennedy in the back of a police cruiser at this point, and they're trying to go through basic questions with her. What's your name? Where were you going? Have you been drinking? They, first of all, didn't see anything in her demeanor to suggest she had been intoxicated. There was no smell of alcohol. And it was all complicated by the fact that I don't know how else to say it other than she was losing her mind at the scene. I mean, going through my notebook. And we saw this on video because it was on the police camera. This young woman hyperventilating, vomiting, crying, shaking, going into the fetal position. And then it sort of hits you as like, well, why? Well, why? She just killed somebody, just hit a little girl. And as I said, like, Baeleigh was still alive at this point. So you have her on the phone with her own mom saying, "Mom, I hit a kid. It was an accident." Like, Baeleigh was still alive at this point. And then they get into the questions, and that's when things start to get complicated.
Things got complicated in part because cannabis had only been legal for a few years. And so we talked to Dan about this. We had no cases in Saskatchewan of someone charged in an automobile accident while allegedly impaired by cannabis. And because of that, the case against Taylor Kennedy was seen to be significant.
It's such a weird thing because it's such a terrible story and such a tragic story, yet it has such a direct bearing on the world that we live in right now, because we had never had a court case that tested cannabis impairment causing death. And the defense's mantra from the very beginning was presence does not necessarily mean impairment. And this triggered a whole series of stories. Like over the past couple of years, we've taken a number of deep dives on various aspects of this case. And one of them is the cannabis testing. And that really emerged as an issue. Yes, she tested positive during the swab, but that had been from 24 hours earlier. And the timeliness of the blood test and the sequencing of all of that just became really critical issues as it went along.
And now we don't have an answer to that because the charges have been stayed. So tell us about how we got to that point.
That was something that we'd sort of forgotten about, because when the case first happened, it became, the issues that came up at the start of the trial and around the charges were the availability of cannabis testing and presence and impairment and all of this stuff. As we got deeper and further into the trial, the issues became more constitutional, I guess, because that was the tactic that the defense took. It was basically this woman was involved in a terrible accident, had volunteered information. This is the defense's argument that they were making. Had been involved in a horrible accident, but was detained and gave admissions that she shouldn't have given without a lawyer present, and it all should have been thrown out. And those were the arguments. Those are charter and constitutional arguments. So those got really narrow. And there were all sorts of intermediate steps throughout the course of the trial. And this came up, were there delays, whether intended or accidental, because had they miscalculated how long they were going to take to run the trial? What about the constitutional questions? What about the experts? So while this is happening, the clock is ticking away, but we're running through the issues. At one point, the defense had raised what had happened the day that the case was thrown out, for lack of a better expression. There was actually supposed to be two decisions that day. The first one was on the delay aspect of the trial, and the second was on the constitutional arguments. And the delay was one that we had the journalists who were covering it, and I think people watching it, had sort of slept on a little bit, because it's tough to calculate. I'll give you the quick delay 101 here. Back in 2016, the Supreme Court of Canada came out with a ruling called the Jordan decision. And in 2016, there was a concern across the country that there was just getting to be lawyers and the judicial system were getting a little cavalier about their requests for adjournments, and cases that would typically have been resolved in 6 months or 8 months were stretching into a year and a half to 2 years. So the Supreme Court came out with a set of rules. It was called the Jordan case, but it basically set a ceiling of 18 months in provincial court and 30 months at Court of King's Bench from the moment somebody is tried to the moment the case is wrapped up. It goes to the judge for their decision. And the argument being is a justice delayed is justice denied. You have to keep track of these things and you have to move it along. And if you go past that ceiling, there's a chance that the charges will be thrown out because of delay. It's not unique, but it is unusual when it's happened. We've had a couple of cases at the provincial court level and at the King's Bench level where they have been thrown out. So when this came up, we went to court that day. I think most of us were caught up on the constitutional arguments, what was going to happen here with those decisions, because we didn't have a clear handle on the time. Judge Wooten, when she started giving her decision, got very granular right away. And we all sort of started to get the inkling in our head as she was doing that was, is she going to stay the charge, or does she just have to go through and do the math? Mm-hmm. So whatever your decision is, you have to have a mathematical basis for it one way or the other. So she spent the 2 hours going through it, that a Crown had argued that the complexity of the case and issues around the pandemic were what pushed them past the so-called Jordan ceiling. So what happens, say, in this particular case, because they went over the 18 months, then it becomes up to the prosecution to make the case as to why it went longer. The defense has said, hey, we came and we made our defense. So it was the Crown that had to justify it. And in this particular case, the judge just didn't accept it. She said, yes, it is a complicated case, but there was, one victim, one accident scene, 1 day, limited number of witnesses. Yes, there's charter arguments, but we've handled charter arguments in the past. It's not perhaps as complicated as you might say. The other less clear was the impact of the pandemic, because the pandemic did cause all sorts of problems with the court system at provincial court and King's Bench. Things were delayed. It was tough. Jury trials were delayed. We all lived through this, so we know about these delays. But we had never gone through it. And what the judge ended up saying was, I can accept intellectually that it makes sense that there would be delays, but without some mathematical formula that we all agree on, I can't come up with a number. So we just have an idea that, there might have been some delays, but not months.
So does that make sense to you? How did you react when you heard that this was her decision?
I didn't think she would have the nerve to stay it, for lack of a better expression. The stakes were so high, the emotions were running so strongly, and there were so many things that we wanted to find out, like presence and impairment, that it just seemed like the most ridiculous thing to trip over. And yet that's exactly what happened. I couldn't believe it when I heard it. Although, yet when I look back on it and you go through the math, well, yeah, they were over. Mm-hmm. And as the defense lawyer said, this wasn't weeks over. This was months. This wasn't bumping up to the ceiling. And it's always interesting to talk to defense lawyers because they said, nobody wanted it to end this way. Nobody wanted it to end with a stay. But they said even if it hadn't been the stay, we would have won on the constitutional stuff, and they're going to appeal, and we're going to beat them on appeal. Okay. I guess not lacking courage of their convictions there.
So what has been the reaction to all of this?
Well, the FSIN sponsored a news conference with the family and from Rochelle Dubois Cook's Home First Nation. They were actually really reasonable in the sense that they had actual suggestions. It wasn't just is maybe the wrong word. It wasn't people just saying racist justice system, things have to change. We've heard that.
People have said that, though.
Yes,
yeah.
and we've heard that before. That's not a new stance. They actually came out with specific ideas that there has to be more aggressive and rigorous case management to keep track of the timing on these. And under no circumstances should there be a stay for delay in the death of a child. Like they have very, very specific ideas. Whether that will go anywhere, I'm not certain. But they were suggesting very specific changes around the whole case because of that.
That is the CBC's Dan Zakreski. Now, at this point, the Crown is appealing, so the story's not over. It leaves many questions, though, for people like Dan to continue contemplating.
I think it was a very good reminder of just how close to the edge the system is. And when I say system, I mean capital S justice system. I had done a story just about a month and a half, 2 months ago on trial delays at King's Bench because of a shortage of judges. That plays into this as well. And that's in terms of the pandemic stuff. Like, it's just all of it. If you don't have enough judges, that doesn't give you the wiggle room to just reschedule something a week or two later. And where this really came home for me was, of all places, during the postal strike, because I was thinking about these things. Because coming up in January of 2025 are a couple of scheduled trials at Court of King's Bench on the Megan Gallagher murder. While those are judge alone at King's Bench, they had some King's Bench jury trials set, and they were delayed because of the postal strike, because they couldn't get jury summons out in the mail. So what that means, though, is you have a trial that was set for January of 2025 that is now in October of 2025. And this is a sexual assault involving alleged sexual assault involving a local massage therapist. We know right now that October of 2025, they'll have blown past Jordan by a considerable margin. So the issue already now in January is what's going to happen in October. Is there going to be a stay because of delay in this? Or are there going to be some institutional provision because the postal strike is to blame? Or this is what the Supreme Court said, and this is how it's going to be, and if you don't want to get these things thrown out, then fix it. But it was a whole bunch of stuff came together on this. The legalization of cannabis, the pandemic, the shortage of judges, the training of police, and just this horrible, can't stop seeing this little girl on a scooter going up a sidewalk. Doesn't matter how many times I watch it, you know how it ends every time. And I think that's what's so terrible for the family and everybody involved in this. We all know the ending, and we can watch it.
It's a terrible, terrible ending. Dan, thanks for this. I really appreciate it.
Well, I hope people talk about it. It's I agreed with the family. People should not forget this little girl. And nor should they forget Taylor Kennedy. She did not get up that morning wanting to kill somebody. And for all of the anger towards her, she lives with this every day.
Dan, thank you.
You're welcome.
That was CBC reporter Dan Zakreski. If you want to hear our entire conversation, it is the most recent episode of our podcast. This is Saskatchewan. You can find it on your favorite podcast app, whether that's Spotify, Apple, or CBC Listen. Just search for This is Saskatchewan. I'm Leisha Grabinski. You are listening to Blue Sky today here on CBC Radio 1. Now, if you're like us, you might be left wondering just how common it is for court delays to result in charges being stayed. We're digging into the legal maxim, justice delayed is justice denied. And we're joined by a couple of people who work as lawyers in different parts of the province. Tyne Hagee is the legal director for the Regina Office of Legal Aid Saskatchewan. Jonathan Bodverson is a criminal defense lawyer and works out of Legal Aid Saskatchewan's Battleford's office. Today he's in Lloydminster. So first, Jonathan, I will say hello to you. Welcome.
Oh, Leisha, thanks for having me.
Yeah, thanks for being here. And Tyne, welcome to the show.
Hi, thanks for having me.
Yeah, you've both been listening to my conversation with court reporter Dan Zakreski, and of course, you will hear things differently than, say, I would or the average person listening. So what stands out to each of you about the Kennedy trial? Jonathan, I'll start with you.
So, unfortunately, Leisha, I don't really want to get into the Kennedy trial when you start to comment on individual cases that I had no particular knowledge of. It's just that it's tough to get into. So I really don't want to get into that case particular. So I don't want to comment on that.
Yeah, and that's fair. I can appreciate that, and especially you're a lawyer, so you know. But in a broader sense, what are the questions that perhaps it has you contemplating? So not talking specifically about what happened here, but just in a general sense, to know that a case like this, had the charges stayed, what are the questions swirling in your mind?
Well, I think that Dan had outlined the delay kind of application very correctly, and I think that he talked about the Supreme Court making a decision, but it really comes from the Charter of Rights and Freedoms. That decision, it comes from a Section 11B of the Charter, and so those rights and freedoms, outlined a bunch of rights and freedoms that protect individual citizens from the government and the power of the government and the ability for the government to prosecute, put people in jail, and protects every citizen. So that right was called 11B, which is not to be tried within a reasonable time. And so the Supreme Court tackled with what that meant in Jordan. And I think that Supreme Court or the appeal courts may tackle with that again, with more decisions coming out, and with some of the concerns of the public outlining this. The Crown may raise some of those issues in appeal. And I think the court system is equipped to reconsider some of those questions and perhaps come with a decision that balances the rights of the individual versus the rights of the public. And I think that's the best place for those questions to be discussed.
Tyne, we have the rest of the program today to talk about this, so please don't feel rushed. But I just want your initial reaction to what you just heard, Tyne, before we check in with our newsreader, David Shield. What are some of the thoughts swirling in your mind, Tyne?
Well, it's hard. Like Jonathan said, neither one of us was on the Taylor Kennedy case, so we don't actually have firsthand knowledge of every adjournment every day in court. So the only people really who are going to know and be able to truly reflect on what happened are going to be the parties involved, right? Defense, it'll be the Crown. The Crown includes also the police, and it will be the court. And I'm sure that all of those parties are looking back and reflecting and saying, okay, I think it's very fair to say that ultimately we all work as officers of the court to make sure that unnecessary delay doesn't happen. And so I'm sure that all those parties are going to look back and be reflecting and say, hey, what role did I have? In my other cases I have, is there anything I could change within my own practice to maybe have not had this result of delay? But at the end of the day, like Jonathan said, I was, there was a comment made about the judge having the nerve to stay. And I mean, the judge doesn't have much discretion because they have to follow the rules that have been set out, the rules in Jordan, set by our Supreme Court. And of course, they have to look at the charter. And so that judge, it's not whether or not they had the nerve or they can't think about the parties. They have to strictly look at the law and apply the law. And sometimes that's going to be a decision that is not something the public expects.
Yeah,
those are just my initial thoughts.
Yeah, I appreciate that, Tyne and Jonathan. We do have the next about 25 minutes or so, so I've got more questions, and I know we're going to learn a lot from both of you, Jonathan and Tyne. I'm just wondering if either of you have more to say on the Jordan ruling, because again, I think for a lot of people, they may still be trying to unpack, like, what is that ruling? And Jonathan, you did a good job of explaining the charter, but just wondering if either of you want to expand so that people fully understand why that ruling was made. So 18 months for provincial court, 30 months for Court of King's Bench. Just help us better understand that Jordan ruling. Tyne, do you want to expand a bit on that?
Sure. I mean, the Jordan ruling came out to protect accused people, but also to make sure that we have a system where trials, and it's not about trials happening, it's about charges being concluded. Charges are being concluded in a reasonable period of time. And we mostly talk about Jordan in the context of charges being stayed and that being a benefit to the accused. But we also have to look and say, in generally speaking, when things are when we don't have a Jordan delay decision, what Jordan does is it holds all parties to a certain set of rules and standards. We shall all aim as officers of the court, as lawyers, as judges, as police, as crowns, to make sure that we are understanding that matters need to move forward, not just for the accused, but for people involved, for witnesses, and for families. And I know it's very difficult for people to take what I'm saying now and think of that in the context of the decision, because of course people are upset and families and witnesses are upset because they have experienced a great loss and they feel that there's no justice. But ultimately, when things are going well, Jordan actually helps us move things through faster, and it holds everyone accountable. Maybe Jonathan can expand.
No, Tyne, you're doing an excellent job.
Yeah.
You're helping me wrap my head around this. Jonathan, maybe you could help us better understand that phrase, justice delayed is justice denied. I want to better understand like what that really means.
Yeah, and I can go back to the charter. When Jordan came out, we had the Charter of Rights and Freedoms, and Charter of Rights and Freedoms came out, and there were lots of court cases about how each charter right was interpreted, and 11B was not really interpreted till Jordan that maybe it meant done by 18 months or done by 30 months. So it was kind of important for the system to kind of have some guidelines and some structure to move with. And justice delayed, justice denied, one way I kind of see it, especially for the individual who is at charge, who again may be innocent, right? We're dealing with a lot of people who are charged who actually are innocent. Not everyone that's charged is guilty, right? We defend people who are innocent all the time. And we try to get innocent people acquitted. And we know of false confessions. We know of false convictions, things overturned by DNA evidence. So people are innocent and charged with crimes in Canada. So if there was no time frame, what does it mean? How long are you going to wait for this matter to be delayed? Is it going to be 5 years, 10 years, right? If you're stuck in custody on remand, are you going to be waiting in jail 5 years, 10 years for your decision for the thing to be resolved? Even if you're out on release in the community, there may be conditions you're on in the community that restrict your liberty. Are you going to be on those conditions for many, many years until this matter is resolved as an innocent person? Right? Mm-hmm. They're presumed innocent until they're guilty. So unless they're found guilty, in a lot of ways I like to phrase it, because sometimes they are still innocent even after the matter is resolved. So that would, in my view, see the justice delayed. If someone's in jail, someone's on conditions, someone's having the fear of what's going to happen, the unknown, the uncertainty of the court case over your head for almost a decade, mm-hmm. if the worst case scenario, mm-hmm. Would be justice denied.
Yeah. What about the victim, Jonathan? How would you address, or how would you explain that to the other side?
It's hard. Like, criminal defense lawyers always have trouble trying to explain how our system works for the victim, right? The system is, we always hear this phrase in many things like democracy. It's a horrible system, but it's the best we got, right? We're dealing with a system that is inherently flawed, but it's a good system because we're dealing with people accusing you of doing something, and the end result is that you go to jail and lose your liberty and removed from society. But if you're innocent, we don't want that person going away. And so the victim may not understand it when they're the victim, but they may understand the importance of rights and freedoms when it's their brother, their sister, their cousin who's charged with a crime they didn't commit, and they're being hung up by the system. So you may not understand it until you need to understand it, and that's when the system is, prosecuting you with a crime that you're saying you didn't commit, right?
I want to remind people that you can share your thoughts on what you're hearing today by sending us an email, bluesky@cbc.ca. Our guests today are Jonathan Bodverson, a criminal defense lawyer who works out of Legal Aid Saskatchewan's Battleford's office, and Tyne Hagee, the legal director for the Regina office of Legal Aid Saskatchewan. Tyne, how often do we see charges stayed because the trial took too long? So I do want to emphasize, like, this Taylor Kennedy case getting a lot of attention right now, but it does make me wonder, well, how often does this happen?
Yeah, it's very infrequent that it happens. In Regina in the past year, I can only think of one case that stands out in provincial court where this happened. And so it's quite uncommon. It's one of those things, though, that when it does happen, it usually does make the news and it's on top of everyone's mind. It's something that, though, in both provincial court and Court of King's Bench, I don't have the stats in front of me to say this is how many cases were ultimately stayed because of a Jordan application or because the Crown, knowing that there would be a successful Jordan application, preemptively stayed. But it's very far and few between. I mean, we have thousands it's about 10,000 people going through our court system in Saskatchewan every year.
Wow.
And really very limited our stat. I couldn't, the percentage would be so low that I wouldn't even be able to make a guess, but it's very far and few between.
And I recognize you weren't the lawyer in the other case that you just mentioned. Are you able to give us a sense of why that those charges were stayed in that case? Just a broad sense?
Just a very broad sense. I had skimmed the decision, and I don't remember the name of the decision off the top of my head, but it was a case with a lot of pretrial applications. It was a sexual assault case with multiple pretrial applications. I'm not sure if there was any other issues, if there was evidentiary or like disclosure issues, or if there were other types of issues. But it was a provincial court case, right? So it had to conclude within roughly that 18-month window. Again, accounting for, sometimes delay can be explained, sometimes delay can be unexplained, but things do need to conclude within 18 months. So that case, I don't recall how long it took to conclude, but it was over the threshold. Right. And so the judge ultimately stated.
And I do want to ask each of you about some of the things that Dan Zakreski brought up, right? Like the delays we saw through COVID, a judge shortage. We'll get to that, but just in general, Jonathan, do you want to add to that? Tyne laid out her perspective, but just do you have anything to add there on how often we see charges stayed?
Sure, I appreciate that. And yeah, Tyne works down in Regina, so she has the perspective on Regina. I work up in North Battleford, which covers Lloydminster and North Battleford and some circuit points around there. And I think I looked at my numbers in my office. We have about 1,000 plus cases going through the court system every last year. So 1,000 cases that delay applications could have theoretically been made on if it ever got to that point, and 0 got made in my office. The private bar may have made some, but I am not aware of them. Legal aid, I think, represents 10,000 cases on their own, so there might even be more than that. And again, it's rare and exceptional that these applications are made. Defense lawyers are, like, as Tyne said, we're very discerning. We're not trying to pick every case to make delay applications on. We look at why the delays were made. If it's even close to that, we're discerning. We don't want to be, the one bringing a delay application in every case and winning on a technicality. We look at why delays were made, and a lot of times there are situations where internally we decide, this is not a case for delay application. We're not going to bring that application. And we work in small areas where everyone's kind of keeping each other accountable. And I think it becomes very rare and exceptional that these applications get made. And when they get made, it is a big deal. Like, everyone kind of is aware of it, but it is becoming more rare and exceptional than that. I'm not even aware of any applications currently.
What impact, though, did COVID have on the court system? Right. Like, it's kind of a blur, but I know things were put on pause. That must have created a backlog. So just, are we still dealing with the impacts of the pandemic, Tyne?
I don't think we are at all. Our time to trial across the province is very good. We're doing incredibly well compared to other provinces. And COVID, there was a backlog during COVID, but I found in my areas, I was practicing in Moose Jaw and Regina primarily during COVID, the courts did a very good job in triaging matters and making sure that there was an appropriate amount of time. So if we were on we were social distancing, or there's limitations on how many people could be in the courthouse, we had prelims and we had trials running out of hotels, out of conference rooms. And so there was a huge push to make sure that delay during COVID was not an issue. And it did not appear to be an issue. Cases that needed to go ahead were prioritized, and cases that could resolve, judges, Crown and defense were all very preemptive, having case managements to see and to actually work out resolutions to have a lot of cases.
Jonathan, do you agree?
Not need to proceed to trial.
Sorry, Tyne, I didn't mean to interrupt you.
That's okay.
Jonathan, do you agree?
Yeah, during COVID, it was on the legal aid side of it and the Crown side of it. The private bar is uncertain. I wasn't involved with that, but I would suggest that most of the parties pulled up their bootstraps and we tried to make deals where it was possible. Where it was, we're looking at non-custodial sentences. How can we get someone a non-custodial sentence and try to resolve the matter without having to? So yeah, I didn't see the backlog, and if the backlog was there, it's definitely gone by now. Like like I was in court the other day and I got a trial offered in 2 weeks. And I was like, whoa, that's almost too quick for me to prepare in 2 weeks.
Mm-hmm.
So you can get trials very, very quick turnaround. And as Tyne's point there, I actually ran a jury trial at an offsite, Don Ross Center in North Battleford. And yeah, I was questioning witnesses from like 60 feet away. It was very awkward and unnerving, but we did it. We got through it. Jury trial happened and it got resolved. And each juror was like 10 feet apart. And so I think there was some things that were worked out and figured out on the fly, because I think everyone in the justice system, even the defense lawyers, are looking to make the system work.
So now, and now that we're past that period, even though both of you say, things were able to move along quite quickly, what are the other complicating factors for a trial? So one of the things that I've read a bit about, and I want to hear you explain it better, but just how complicated trial or cases can be, and I'm wondering about the amount of video footage and how, I don't know, when cases become more complicated, what would make a case complicated, and what is the impact of that? Tyne?
Yeah, so you mentioned video footage. I mean, everything is recorded now. So we get files, and you can imagine that if you commit a crime, there's probably a doorbell camera somewhere in the city that's captured you. And so we do have higher volumes of material coming from the police to the Crown prosecutors, or RCMP to the Crown, and then from the Crown to us. And so there is a higher volume of material to review. But you mentioned video. We often call video the unbiased witness. Video actually doesn't necessarily increase the amount of trials we have or increase trial time, because video often shows us exactly what happened and then results in things being resolved. But there are lots of things that can complicate a trial or delay, let's say, disclosure and time to trial. One of those is DNA. If they're waiting, on DNA samples, that can sometimes take months, and they go away for testing, sometimes in province, often out of province. You're waiting for those to get tested. Firearms, if it's a trial involving a firearm, those will be sent away for testing to make sure that it is actually a firearm and meets the definition of a firearm. Or cases where you have other types of exhibits like that. Like, we don't deal with a lot of gunshot residue anymore, but there's certain types of exhibits that you have. When I say exhibits, I mean evidence that results in a little bit more complications and more time, essentially, to get to a point where both parties are in a position where they could proceed because they have all the relevant information.
Jonathan, anything to add to that? What might be, what would make a case complicated that could contribute to delays?
Yeah, obtaining the evidence, as Tyne said, that you think is important and relevant to your client's defense, that you believe is in the Crown's possession, but for some reason has not yet been disclosed. You also, expert evidences that the Crown may choose to call because they wish to use that theory to convict your client. You may need to call your own expert, right? Or obtain your own expert to review that evidence, because they're the ones who are paying for an expert with the government money, and you need to respond to that. I think those are kind of the applications. But we're trying to talk about how in the criminal code now there are applications that have to be made under the sexual assault provisions in regards to cross-examining witnesses on third-party records or records that are in the hands of the complainant, like medical records, text messages, all arising of the Jian Ghomeshi case and the provisions of that. That inherently takes time to go through those sections and deal with those issues as well.
Something came up this week at court. Like, the judge in the murder trial of Megan Gallagher actually lectured the lawyers about delays. And at one point, he asked the lawyers to turn around and look at the public gallery. And this is what Judge Daniluk said. These are the people we serve. The justice system doesn't exist for us, the judges and lawyers. It exists for them. What's your reaction to that? Did you think that the Taylor Kennedy case was a bit of a wake-up call to make sure this doesn't happen again? Just how do you react to that, Tyne?
I think that Justice Daniluk, he was trying to say, in only the way that Justice Daniluk can, hey, look around and remember what your role is, because we all have roles. as a defense lawyer, my role is to make sure that if my client is going to be convicted, they're done in a way that's fair and a way that complies with the charter. We often think the role is to have an acquittal, but no, ultimately our role is to make sure that they're treated fairly and rules are followed. The Crown's role is, not to secure a conviction necessarily, but really to present the evidence to the judge in a way. Their objective often is to secure a conviction, but that ultimately their role is to present evidence to the judge, and the judge's role is to decide. And so we sometimes in an adversarial system forget about our roles, and that we are all, at the end of the day, officers of the court. When I say that, I mean we all, as members of the Law Society, need to remember our roles, and we can be adversarial, but at the same time, we do serve the public. So I think he just wanted to remind them of their roles.
Jonathan, what did you think of Judge Daniluk's comments?
I do have Judge Daniluk coming up in a trial coming soon, so I don't want to say too much. But I think the legitimacy of the system is important, as indicated before. It's not the perfect system, but it's the best system we got, and having the legitimacy maintained is important, and that means having the public understand the importance of the system, which is, as Tyne indicated, is making sure everyone's following the rules, making sure that the defense has full answer in defense, that they've been able to obtain all the appropriate evidence and material, so that it's not hidden evidence or evidence that they couldn't get because the Crown couldn't get it, or because we're worried about a delay. But at the end of the day, we also need to understand all the importance of the system. So I think it's also showing the public that, and understanding and helping the public that they expect the system is legitimate. We are trying to, as officers of court, trying to ensure legitimacy of that system, and all taking our roles seriously to that.
Do we have enough judges, Tyne?
I mean, I know that there's some federal appointments they're waiting on. Provincially, I know that they're all the appointments I think are filled, mostly in the province. I'm not sure if there's any retirements. It's not just about do we have enough judges, though, because we have to remember that a judge can't go into a courtroom by themselves. They need to have a room to go into. They need to have a clerk who is helping them and monitoring the recording. They need to have deputy sheriffs at the courtroom, right? Making sure that everyone is safe. And so it's not just about having enough judges. The Taylor Kennedy case wouldn't have been decided a different way, I don't think, if there was more judges, because it's about the resources as well that support the judges, and also about the reasons why there wasn't, earlier court time. And again, those reasons are complicated, and Jonathan and I don't know why, because we weren't there.
Yeah.
But it's not just about numbers of judges.
I want to move to one other angle, and I just want to make sure I give you both enough time to respond to this, because the Federation of Sovereign Indigenous Nations is calling for a change to the Criminal Code of Canada to prioritize child victims of crime. This was something that Dan alluded to in our conversation. So the FSIN said it has developed a proposal called Baleigh's Law to prevent a repeat of this case. It suggests giving child victims enhanced consideration in the courts and introducing protections against procedural delays, including regularly scheduled case management hearings with explanations for any delays. What do you both make of this, Jonathan?
Yeah, I'm very sensitive to the FSN's position. I think that they are addressing the concerns in a proactive way, as Dan said, that they're doing it in a proactive way, and I think that's a good thing. My emphasis is, the rights of the individual and the rights against the charges against them, and be able to answer full defense. So, do I want my clients, having a charge delayed for a long time and not getting disclosure? No, right? I want to be able to defend my clients' rights. But I think that, as indicated, I think that the best route is the common law system, and trying to have the judges tackle with this issue through the appeal court. And I think that they'll take it. I think they'll take into account some of the exceptions, some of the concerns, and say, how should a Section 11B be interpreted in this particular case, with this particular situation? And I think the common law system, which has worked over time and is very flexible, I think is the best way to handle it.
Tyne, what are your thoughts?
Well, it's all about balancing, because, for example, to have judicial stays or the ability for a judge to stay a matter involving a death of a child completely limited would mean that there's no checks and balances on the police and the Crown. And so it means that if, as Jonathan said, if disclosure is delayed, it does impact on that person's right to have a trial in a reasonable time and a fair trial. I think, though, that what would make sense is all parties, and it looks like the FSIN is also calling for all parties to kind of step back and say, how did we get to this point? Because perhaps there are things that can be done that don't involve legislative change. So the judges still have their independence and discretion. But to have a look and say, hey, why did this case in particular become delayed? Because I don't really think it's about, there doesn't appear to be a system-wide problem with delay. It's really about why was this case in particular delayed. So I suspect that over time, the FSIN may look into that, or parties may look into that. But that would be those are the thoughts that I initially had when I reviewed their press conference.
I just want to get your final thoughts on what you'll be watching for in this case. Again, I know you're observers in this case. You are not directly in it. But we know the Crown is appealing the stay of proceedings, and so what will you be watching for next, Jonathan?
Well, I think Dan kind of made the point pretty well when he said the Crown tried to make their pitch about why this should meet the exceptional in the second test, which is if it's over 18 months, can the Crown get some more time taken off because it's exceptional? So I think in the appeal court, that would be where I'm looking to see whether or not the appeal court considers those arguments again and balances different exceptions and tries to consider whether or not anything should be more exceptional, or if something should be exceptional like COVID or like whatever other applications were made in this case, again, without knowing the case. But I think that would be looking for is the second test of the Crown making the arguments in the pitch, and whether the Court of Appeal is more open to their arguments this time around than they were at the provincial court level.
Tyne, what will you be watching for?
Well, like Jonathan said, COVID, I mean, we didn't have a lot of delay in particular as well, because COVID was often considered to be an exceptional circumstance, and also very limited trials were adjourned during COVID. But it will be interesting to see how the Court of Appeal interprets that. And I don't think their decision will be about the fact that it's a case involving the death of a child. I think it'll be about when we have very complicated, if it is indeed a very complicated case, because I know some people say it was a complicated case. Other people have said the Taylor Kennedy case was really not that complicated. But when we have sort of novel arguments like this being made, are those types of novel arguments and situations, can that lead to an exception? I don't know what they'll say. I suspect no, but we'll see. And I look forward to reading that decision.
I really appreciate having both of you with us today. I've learned so much from both of you. So Tyne, thank you.
Thank you.
And Jonathan, thank you.
Thank you, Alicia. Have a good day.
You too. Jonathan Vauderson is a criminal defense lawyer, works out of Legal Aid Saskatchewan's Battleford office. Tyne Hagee is the legal director for the Regina office of Legal Aid Saskatchewan. I'm Leisha Grabinski. You've been listening to Blue Sky here on CBC Radio 1. I'll share one email from Al, who writes, "The words should be justice denied is justice corrupt. Isn't our life in a free country the most important protection needed? Not setting an arbitrary time for a trial. Where death is involved, there should not be a time limit, especially when it is a child's life." Thank you for emailing. We always appreciate hearing from you. Our email address is bluesky@cbc.ca.